Have your leave to mention a matter, my lord?
Yes, please.
My lord, this is in respect of an order that was passed by her ladyship, Moushami Bhattacharya, yesterday, my lord. My lord, urgent interim relief is required, my lord. I was praying to file the appeal today, and if it could be taken up today, my lord.
We will permit you to file it today.
My lord, urgent, if I may indicate the urgency, my lord, my lord, this is in respect of an writ petition, my lord, which involved dilution of the eligibility criteria of an empanelment process of inspection agencies, my lord. There was an interim order on the Jute Commissioner, my lord, where the Jute Commissioner was instructed that he could not finalize the empanelment process without leave of the court. My lord, during the pendency of the writ petition, despite this order, I was disqualified from the process, my lord, which is why the urgency, my lord. They would finalize the process, my lord.
We will grant leave to file it today and leave to move it in the first vacation court. Yes.
My lord,
Please give the papers.
My lord, one request, my indulgence, my lord, if I have not been able to obtain a certified copy of the order.
We will allow you to file it
without the order, my lord, because the server is down.
You contact the registrar IT. He will be able to pull it out from the server. You with that copy you file.
Grateful, my lord.
Give it to the court officer. We will grant you leave.
Grateful, my lord.
My lord, I am praying for your lordship leave, my lord. Kind leave, my lord, for filing the stay application physically, my lord.
Oh, physically, yes. Leave granted.
My lord, I'm praying for leave to file this appeal without certified copy.
Yes, leave granted.
May I have you?
Kind leave to file this appeal without the certified copy.
All right, all right.
May I have your lordship's kind leave to file the stay application?
All such requests granted.
Grateful.
Yes, please call the list.
My lord, one pending application before your lordship to frustrate the application. The interim order has been passed by this honorable court. My lord, to frustrate the entire process. My lord, today the SDO, we do not have any jurisdiction to pass an order. In spite of the order of the court, he decided to, my lord, the exculpate.
You file a contempt, we list the contempt.
My lord, kindly see the situation for once, my lord.
But we can't do it anything
My lord,
today.
kindly, my lord, may I say one thing?
There are a lot of other works which have to be done.
My lord, my application will be infructuous if it is done. My lord, for 1 minute.
If there is a violation of an order, you move for contempt, we list the contempt immediately.
My lord, if the drain is excavated, my lord, then my lord, nothing will remain. My lord, what happened, my lord?
File the application, let me see.
My lord, 1 minute only for, my lord,
don't take me. See, we can't take up your case based on oral. You bring something on record.
My lord, I am annexing the document. I am placing this record.
You file a CAN application, we will consider the CAN.
Lord, I'm praying for lordship's leave to physically file an appeal. I have annexed the certified copy, my lord.
What happened to the horses?
Yes, my lord. My lord, out of 16 horses, my lord, we have been, my lord, able to take 9 horses into the custody, but after facing, my lord, great resistance from the owners. Now, my lord, thereafter, my lord, after we have taken them into the custody, our trunk was being followed. And there is, my lord, some issue with regard to, my lord, the safety and security of the persons who are, my lord, guarding the sanctuary.
But I am appearing for the other petitioner, Cave Foundation.
State Council.
But we had served them a notice.
They have been,
You bring them.
At 2 p.m., my lord?
No, now.
My lord.
During our list will be over before that.
Very good.
You ask somebody to come.
Great,
you ask the additional AG.
We are not getting proper cooperation on the police authorities. That's the difficulty we are facing, my lord.
We'll do something. Yes, please call the list.
Appellate side, daily list, under the heading for judgment, serial number 1.
For the respondent.
For the
Private respondent.
This history. Each page I have to correct the right. I will ask you to check. As already noted, if the nomination is in accordance with Form C, there could be no ground to reject such nomination, and the reasons set out for rejection of the nomination of the writ petitioners are clearly outside the scope of the requirements to be complied with in Form C. Thus, I am fully convinced that the learned single bench was perfectly right in allowing the writ petitioner and directing the objections raised by the writ petitioners to be considered by the committee, which is to be constituted in terms of Rule 5.1 of the rules. In the light of the direction issued by the learned writ court, it goes without saying that the entire election process thus far conducted is required to be scrapped, and the matter should stand restored to the stage where the scrutiny of nominations were conducted. Thus, the election process needs to be pushed back to the set date, and the objections of the writ petitioners as well as other 21 candidates whose nomination were rejected has to be considered by the 3-member committee. I am of the further view that there should be an observer nominated by the government to ensure that the entire election process is conducted in a free and fair manner without any irregularity or complaints. Therefore, while affirming the decision of the learned single bench, directed that not only the correctness of the rejection of the writ petition should be considered, but also such of those 21 nominations which were rejected, whoever files objection is required to be considered by the committee in terms of Rule 5.1 of the election rules. In order to ensure that the election process is conducted in a proper manner, we direct the Secretary, Ministry of Health and Family Welfare Department, Government of West Bengal, to nominate a senior officer of the said department to act as observer to ensure that the election process is conducted in a free and fair manner. The observer is required to make known all the developments, and all actions and decisions shall be taken in the presence of the observer. The appellants are directed to publish a notification giving the text of the directions issued by this court, directions issued above, and making it known that all the 25 candidates whose nominations were rejected would be at liberty to file their objections within 3 days from the date of publication of the said notification, and the objections shall be dealt with in the manner as directed by the learned writ court. With the above direction, the appeal is dismissed.
Lord, I'm grateful, my lord, since
Wait.
I'm unable to, with deepest of respect to the Honorable Chief Justice, I'm unable to agree with the reasoning as well as the conclusions arrived at by the Honorable Chief Justice. For such reason, I'm recording my findings and conclusions hereinafter. The learned single judge was of the view that the rejection of nomination of the writ petitioners caused serious injustice to them, and for such reason, the writ court interfered in the matter. The learned single judge also took great pains to look into the reasons for rejection of nomination to ascertain as to whether such rejection was proper or not. Furthermore, the learned single judge was of the view that the rejection of the impugned, that the objection to the impugned rejections was within the parameters of Rule 5.1, as according to the writ court, there is no time limit within which such objection is to be taken. On such findings, the objections against rejection of nominations were allowed. Thereafter, the rules were quoted. The word forthwith has been defined in Black's Law Dictionary to mean immediately, without delay. It also means directly, promptly, within a reasonable time, under the circumstances. Upon a harmonious reading of sub-rules 1 and 2 of Rule 5, I hold that the objection against rejection of nomination is to be made immediately and without any delay. That is, it should be made at the spot or within a reasonable time immediately thereafter. Even if for some reason the objection against nomination could not be made at the spot, the same has to be done within a reasonable time. Reasonable time, however, shall depend on the facts of each case. In this regard, it is to be borne in mind that the list of nominated candidates are to be published after the last date of withdrawal of nominations, and several steps are to be undertaken thereafter in terms of the relevant rules, more particularly Rule 8 thereof. Thereafter, some decisions of the Honorable Supreme Court were considered. The issue of rejection of nomination papers was raised in Ponnuswamy Supra, and it was held that writ petitions challenging improper rejection of nominations should not be entertained. Mohinder Singh Gill Supra and Ashok Kumar Supra did not express any view contrary to or in conflict with the view expressed in Ponnuswamy Supra on the maintainability of writ petition against rejection of nominations. In view of the aforesaid discussion and observations, I hold that the decision of Ponnuswamy Supra still holds the field on the issue involved in this appeal. It is accordingly held that the approach made before the writ court challenging nomination form cannot be said to be a step to facilitate the election, and rejection of nomination papers is a dispute arising out of election, and improper rejection of nomination can be a ground to challenge the validity of an election. In view of the aforesaid well-settled binding precedents, the question raised in this appeal has to be necessarily answered in the negative. I therefore hold that improper rejection of nominations cannot be assailed by filing an application under Article 226 of the Constitution of India, and the learned single judge was not justified in allowing the objection against rejection of nomination while the election was in progress. For the reasons as aforesaid, I am inclined to interfere with the order impugned. Accordingly, this appeal stands allowed. The impugned order dated February 28, 2023 stands set aside and quashed. Consequently, the writ petition being number such and such stands dismissed. There shall be a direction upon the returning officer to conclude the election process and to publish the result as expeditiously as possible, but positively within 4 weeks from the date of receipt of the server copy of this order. The respondent numbers 1 to 4, as well as any other aggrieved person, are left free to approach the competent authority as per the 1948 Act and the rules framed thereunder for referring the dispute in accordance with law if they are advised to do so. There shall be, however, no order as to costs. I make it clear that I have not gone into the merits of the objections raised against the order of rejection of nominations, and the same are left open to be decided at the appropriate stage.
So in view of the differing judgment, it will go before the third judge.
My lord,
So you'll have to wait.
my lord. My lord, only one indulgence, my lord. Since the server is not working, may I be permitted to get a plain copy from the SEO, my lord?
I think so. Some corrections are there.
Yes, my lord. In the evening, we shall wait, my lord.
We'll ask.
Serial number 2.
Dismissed. Yes.
I agree.
serial number 4,
Data matter.
Horses matter. Yes.
My lord,
We'll finish this.
my lord, this case has got a very checkered history, my lord. The mother is the writ petitioner, my lord, and my lord, only son, daughter-in-law were the private respondents in the writ petition. Mother filed a application under section 23 of the DV Act. It was challenged by the son. It was dismissed in appeal, my lord. Son was directed to pay amount rupees 7,000 per month, which he has been paying very diligently. I have annexed all the documents, my lord.
Now
Now,
the
my lord,
appellant is his son,
yes, appellant is the son and his wife. I
daughter-in-law.
mean the daughter-in-law.
The writ petitioner was the mother.
Yes, my lord. 82 years. The house property stands in the name of grandfather of the appellant, my lord. They have been residing in the premises since his birth, my lord. Now he is residing along with his wife, I mean the second appellant and their minor school-going daughter. Now, my lord, what happened, my lord? The writ petitioner filed an writ petition, my lord. Kindly straight away come to the prayer, my lord. That is at running page 41, annexure P. I have annexed the entire writ petition. What was prayed for actually? A writ, as your lordship got that?
Page number?
Page number 41, running page 41, my lord. Internal page 12, annexure P. What was actually prayed for in the writ petition? Page 41, annexure P. Has your lordship got it?
Yes. Yes.
Yes. My lord, that is prayer A. A writ in the nature of mandamus commanding the respondent authorities and their main and agents, particularly the respondent number 4, that is the police authorities here in my lord, to comply the aforesaid order dated 16/11/2019 passed by the learned 6th Judicial Magistrate at Alipur, which is also affirmed by the learned 9th Court of Additional District Judge at Alipur by the aforesaid order dated 16th July 2022 passed 4 to it. And this next pair, writ in the nature of mandamus, commanding the respondents, their main agents, particularly the respondent number 2, my lord, the police authorities, to take action against the erring police officer attached to the concerned police station for its inaction, non-actions in discharging their duties to give protection to the life of the petitioner and her unmarried daughter, in spite of specific order dated 16/11/29 passed by the learned 6th Judicial Magistrate, which is also affirmed by the learned 9th Additional District. Now, my lord, kindly come to what was the order actually, that is at page 49, the ordering portion. My lord. I am not troubling your lordship. 48 and 49, annexure P2. Proceedings under section 23 of the DV Act.
9,000 rupees.
Yes, 9,000 rupees. That was appealed against, my lord. That was appealed against. Then, my lord, kindly in between, my lord, there was a counter FIR, my lord, by the appellant number 5. I mean the wife of the daughter-in-law under 498. That is going on, my lord. Section 498, section 91 notices was served. That is under investigation. Now, my lord, kindly come to what was the order affirmed. That is at page, my lord, 57 by the learned additional district judge, additional district and sessions judge, pursuant to the appeal of the appellant number 1.
Yes.
That the criminal appeal number such and such is dismissed on contest and the order of the learned court below is hereby affirmed. Let a copy of this order be sent to the learned court below for information. My lord, I have not challenged that order anymore. I have been paying the compensation. I have also annexed the KMC tax receipt of the premises, which I have been paying very diligently. I have annexed, kindly come to the annexure P3.
No, you file a suit for partition.
No, my lord.
You file a suit.
I'm telling you, I'm covered by a Supreme Court judgment. Lord. Kindly hear me for minutes. Kindly hear me, please. Money receipt, my lord, I have filed. Now, my lord, what happened, my lord? Honorable Justice Mantha, my lord, directed, my lord, kindly come to the impugned order. That 123, my lord. Lord, how the entire family, along with their minor daughter, have been ousted, my lord, without any notice, my lord, to that effect by the police authorities. Only because they have got a special, they have got a residence of their own in a far away place. I have been ousted from the shared household. On this point, my lord, kindly have a look at the latest Supreme Court decision. 2020 SCC Online Supreme Court, conflicting legislation. My lord, Senior Citizens Act 2007 and my lord, PWB. Reported judgment, you note Koruna, 2020 SCC Online Supreme Court. My lord, kindly come at the bottom of the first page. And also the head notes, my lord. The middle of the head notes.
Yes.
While senior citizens are entitled to protect their property rights and to be secure in their old age, the woman cannot be divested of the protection to stay in the shared household. The purpose is that neither of the parties rendered shelterless. The tribunals constituted for senior citizens cannot pass a blanket eviction order in senior citizens' favor, ignoring the protection which the women are entitled by of residence order in shared household. And my lord, kindly come to the last 4 lines of this page.
Yes.
Both the sets of legislations have to be harmoniously construed. The right of a woman to secure a residence order in respect of a household cannot be shared household cannot be defeated by the simple expedient of securing an order of eviction by adopting the summary procedure under the Senior Citizens Act 2007. Now, my lord, relevant paras are 20, 21, 22, 24, etc. This is a landmark judgment of my lord, Honorable Supreme Court in the case of S. Banita. And this was also followed, my lord, also followed by the Supreme Court, my lord, in the next judgment, 2021, one Supreme Court cases, 414. The same, it was recorded, my lord, in para 89 and 89. Kindly have a look at it. Para 89 and 89. and 90 mil. Internal page 461, mine.
Yes.
Now, I'm reading out, my lord. Now, coming back again to the facts of the present case, there being specific pleading on behalf of the respondent that the house which is in the name of appellant is the matrimonial home of the respondent, where she was residing in first floor since her marriage. The fact that respondent is residing in the first floor of the premises is not matter of dispute. Even if the house is in the name of the appellant, and that even if we accept the case of the appellant, that appellant's son Ravin has no share in the house belonging to the appellant with whom the respondent was living in the domestic relationship, whether the respondent is entitled to reside in the premises in question as shared household is the question to be answered. In the impugned judgment, the Delhi High Court has refrained from deciding the point as to whether suit property is a shared household on the ground that the application filed under Section 12 of the 2005 Act by the respondent is pending. In the suit filed by the appellant, where the respondent has pleaded and claimed that it's shared household and that she has right to live, that it was on that ground she was registering the suit for mandatory injunction. The question that whether the suit property is a shared household or not becomes relevant and necessary, and the said issue cannot be skipped on the ground that application under DV Act is pending. In the regular suit which has been filed by the appellant, the plea that defendant in the suit that suit property is a shared household and she has right to residence could have been very well gone into by virtue of Section 26, which we shall further deal with later. Then we will kindly come to para 90. Before we close our discussions on Section 2S, we need to observe the right to residence under Section 19 is not an indivisible right of residence in shared household, especially when the daughter-in-law is pitted against aged father-in-law and mother-in-law. The Supreme Court has also considered that aspect also. The senior citizens in the evening of their life are entitled to live peacefully, not haunted by marital discord between their son and daughter-in-law. There was a dispute between son and daughter-in-law, not with the mother. While granting relief both in application under section 12 of the 2005 or in any civil proceeding, the court has to balance the rights of both the parties. This is what, my lord, absolutely absent in the impugned order. The directions issued by the High Court in para 56 adequately balance the rights of both the parties.
Yes.
So, my lord, what order was passed, my lord, in pursuant to my interim application, kindly come to the order dated 22nd of March, my lord. Appellants couple, my lord, and my lord, their minor school going daughter, my lord, are having, my lord, extreme hardship. Their place of residence, although their own, my lord, is a faraway place, she is facing extreme difficulty to pursue her studies, go to school and come in between. My lord, the possession is theirs. It is under their lock and key, but they are not allowed to reoccupy the same. My lord, kindly come to the, what is more unfortunate, my lord, kindly come to the order dated 22nd of March 2023, passed by your lordship. Yes, your lordship. Now, pursuant to my application, my lord, it has been misinterpreted by the police authorities. On 13th, my lord, I made a application to the Judge Sahib for taking some valuable documents, etc. That has not been, yes, that has not even been allowed, my lord. On more than 5 days have passed. They are saying that they will have to take consent of the writ petitioner, so times will be needed. Now, my lord, first submission is, my lord, I am entitled to reoccupation, my lord. That is my shared household.
Right. That we will consider.
Yes, grateful to your lordship.
Yes. Who appears for the mother?
My lord, I am for respondent number 5, my lord. My lord, kindly come to page 6 of the petition, my lord. The grounds they have stated that
Petition is
no,
there.
no, not it petition. This MAT petition.
Which petition?
In the appeal.
Appeal.
Yes.
That's ground number 7, my lord.
Yes.
They have stated that without even giving a single day's time on only
Yes.
24 hours to the appellant. My lord.
Yes.
My lord, I have instruction, my lord. They have got more than 10 to 15 days
No.
to carry out all the belongings, my lord, of the petitioners of the yes, my lord, for this petitioner.
No, notice from the police authorities were served upon me that you will have to shift from your residence. They cannot show even a
And
single piece of paper.
what happened to the complaint given by the mother about the son? The court has recorded,
Yes.
if you see the learned single bench's order, it appears from the report on an allegation of assault of the petitioner by the private respondent, FAR charge sheet number 256 of 17 has been filed by the police. What happened to the matter? Still pending?
My lord, that is, my lord, if my lord kindly sees, the FIR was started on that very day when the order was confirmed, affirmed by the appellate court. There is a district judge, my lord.
No, that is on the monthly maintenance. That is up,
Monthly maintenance.
and they have not challenged that order passed by the district judge.
They have been
And
paying.
according to the council, they have been paying that 9,000 rupees.
Not regularly, my lord.
Yes,
They are-
No, that you can always approach the.
I have annexed, my lord, all the receipts, money receipts.
All three of us can't talk.
No, absolutely.
So that if he is not complying with the decree, your remedy is there. But the court records that charge sheet number 256 of 17 has been already filed by the police. What happened to the matter? Trial has started.
my lord, trial is not yet started, my lord. Charges yes to be
And
framed.
what is the dispute between?
My lord, 82 years old mother, my lord, widow, and the daughter of the mother, my lord, is mentally ill, my lord. They have nothing to do. They can't even reach before the court, my lord. Finding junior counsel, they have contacted us. So I am just I have come before the court to.
And any record regarding the medical condition of the
My lord,
unmarried daughter, have you produced it?
no, my lord. If time is given, my lord, I will file before this court.
But
my lord.
in your writ affidavit, you have mentioned that.
No, my lord, I have filed only on behalf of the mother, my lord, because as the daughter is ill, my lord, I have not made her a
No,
party.
please, is there any averment saying that she is not
No.
healthy,
My lord,
etc.?
in the my lord, the DV petition, my lord, I have filed there, my lord. I have submitted. I have made affidavit, my lord.
Which thing? Let them show.
Annex করেছেন কি না?
Yes, they have said, in their complaint, they have said, I have been blessed with 4 daughters, among which one unmarried daughter named Swapna Saha, who is also living with me, is a mental patient and was recovering by physician's treatment. But due to cruel behavior and treatment of Shekhar Chandra Saha and his wife Momita Saha, my said daughter have developed illness.
Milord, there is also an FIR by the Momita Shah against the daughter-in-law. Milord, section, in that
Mother-in-law.
mother-in-law and her wife, that are there in there also, Milord, the charge sheet has been submitted.
Petitioner,
What I am praying for, Milord, on
stamp the page, I get the purchase.
Milord,
But the only issue will be whether a writ court can pass an order of eviction.
yes,
My lord,
grateful to you, Lord.
That's the only
my
issue.
lord, there are several,
Probably on facts, you may have a good case because you have succeeded under the DV Act.
yes,
And there's a decree in your favor, there's no problem. And you have also lodged an FAR, charge sheet has been laid. And there is an averment saying that false complaint has been given by the daughter-in-law against the mother-in-law. There is also a counter FAR.
Milord, there is also a charge sheet, Milord,
Charge sheet has been laid.
page 98, Milord,
Milord,
pursuant to daughter-in-law.
my lord, petitioner is a LIC agent, my lord. He have.
You have also filed a
capacity to-
498A.
Hmm.
Yes,
So
no, I am saying the case.
My lord,
and
on the
count.
date, my lord, kindly note
page
the date, my
32,
lord.
paragraph 5.
On the date of the very date when the appellate
writ
court
petition.
Yes.
ordered that, on that day of the FIR was registered, my lord, on the specific date. It's totally concocted, my lord.
But there is no chance of any mediation.
Yes, Milord, there is always,
My lord,
always, only son, Milord, they are,
No, if the son and the mother alone speak,
yes,
matter can be
yes,
solved.
in presence of any impartial,
It can't happen.
yes,
There is bound to be other siblings who has their vested interest.
no, there is no other sibling, only one son and that
Not the daughter.
alleged,
If the mother and the son,
yes,
Then it can be worked out.
yes, Milord.
if the daughter-in-law comes in.
No, 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 no.
Because she has lodged a FAR.
Yes. Milord, as your lordship, Milord, directs, Milord. There is no need for the daughter.
But she has said that physical cruelty has been meted out to her.
No, Milord. That's a disputed question of facts, Milord. There cannot be one side of coin. Your
No, no.
lordship knows, Milord.
There was a counter FIR in 2017 that might have been a different issue. You have now lodged the complaint on the date when the writ petition order was passed in 2023. Charge sheet filed in the year 2017. And you are facing trial, you are dragging on the proceedings.
yes, my lord.
And
No,
the
Milord.
son has suffered a decree before the, which has been affirmed by the a district court. And you have not appealed against that order. The findings recorded there, prima facie, I mean, not prima facie, conclusively says that you have not taken care of her. That finding is, has become final.
Milord,
So
that is-
therefore, it's a everything, as per the order passed by the civil court, you have been held guilty of meting out cruelty to her.
Not-
So how do you get over that finding?
Milord,
So all is not well with the appellant, first appellant.
Milord, if your lordship so directs, Milord, on any condition, Milord, the son is very much eager to, Milord.
I
Milord,
don't know how it will be possible.
may- take a settlement.
We-
Everything is being
No, no, if you,
taken care of, Milord, by
if
son.
both of you agree we'll refer the matter for mediation
Yes,
and let the matter come up immediately after 2 weeks after we reopen after vacation. Let us see what can be done.
yes. My lord. Then let them, my lord, the,
See that finding, you please forget that you are appearing for the appellant.
yes,
They went before the concerned court alleging that there has been violence committed, domestic violence committed. Court, after full-fledged trial, holds your client guilty, both your clients guilty.
yes, man.
Order has been passed.
Order has been
You
by
are, you
judicial
filed an
arrest.
appeal. Magistrate's order has been affirmed by the district
Yes.
court. That finding remains intact. So therefore, you can't escape from that finding.
So therefore, my lord, kindly may I have that.
What is he working somewhere? This first appellant son,
My lord, he is an LIC agent, my lord. He is an agent of LIC.
is he present in the court today?
Yes, my lord.
Where
He
is he?
here? Hey. Ask. Ask your brother. Hello.
Is your client agreeable to go to mediation?
Sir, it is already happened on Alipur in.
Hmm.
I'm ready to.
No. You owe your existence to your mother.
Yes.
You can't kick her out. You can do us if a person is unhappy with the spouse. Your wife is unhappy with you. You are unhappy with her. You can both apply for divorce, contested divorce, or mutual consent. But you can't divorce your mother.
Yes.
Then whether the property is important or the person who brought you into this world is important. Property is grandfather's property.
Of course, ma'am.
Property is grandfather's property. You did not earn and buy the property. If you had invested in the property and then said that my mother and my other siblings are trying to prevent me, that's a different matter. And this is very, very awkward. We can't read a couple of paragraphs of the order passed by the district court. Damaging. And no court will have any sympathy on you, nor on your wife. You are now trying to field your daughter in front of in this dispute. Don't do that. Never ever do that. And the best thing is you have got a separate residence, shift your daughter's school put her in a new school.
He's in
Then wait. File a suit for partition. Because you have got other four daughters totally and one son, 5. Totally you're 5 people. 4 sisters you have got and you are the only son. And one of your sister, according to mother, she is not very, there is some illness she is undergoing. So you file a suit for partition. Because if you had already attempted mediation and it has failed, there is a charge sheet filed by mother and the case is pending running since 2017. 2023, you lodge a FIR and there also charge sheet has been filed. So the dispute has become so bitter. And unless and until you show some remorse, just throwing 9,000 rupees on her face is not going to get everything. You file a suit for partition.
Look, that will be a very long drawn
What
procedure.
to do?
Only she wants the occupation, my lord, only for the sake of her minor daughter.
No. He has
It's very
to,
difficult to
so
change this.
if the matter was pending, let us assume the DV Act proceedings are pending. That's a different matter. That has gone against him, confirmed in appeal, finding has attained finality. So therefore, he is guilty. And how to now say, put him back in the house, etc.
There can be mediation on any condition your lordship may impose, my lord. Any condition.
We will place the matter after vacation.
On condition.
In the meantime, we will record his consent and your consent also. The present dispute is between the son, the appellants are the son and daughter-in-law of the first respondent. Of the fifth respondent. The fifth respondent had approached the Judicial Magistrate 6 Court Alipur and lodged a complaint under the provisions of lodged a case in AC number 3946 of 2017, in which a direction has been issued by the concerned court on 16/11/2019, directing the first appellant to make payment of rupees 9,000 towards maintenance allowance of the fifth respondent within every 10th day of every succeeding English calendar month, failing which the fifth respondent was at liberty to proceed separately for realization of arrears amount. The first appellant, the appellants, not a first, the appellants filed an appeal against the said order in criminal appeal number 280 of 2019 before the additional district and sessions judge, 9th Court Alipur, and by judgment dated 16/7/2022, the appeal was dismissed. Both the learned judicial magistrate as well as the additional sessions judge, while passing the order, have recorded certain findings which prima facie show that the appellants had committed certain wrongful acts, and they were liable to pay maintenance in terms of the PWDB Act. The challenge in the present appeal is to an order passed by the learned single bench dated 1st February 2023, by which the learned writ court, considering the bitter acrimony between the appellant and the fifth respondent, and also the fact that the appellants have a separate residence at Bansroni, Bansdroni. A direction was issued to the police to escort the appellants out of the residence and giving liberty to the appellants to agitate their rights before the civil forum with regard to their right of residence in the said property, which admittedly is a property belonging to the grandfather of the appellant. When this appeal was admitted, an interim direction was issued on 22/3/2023, permitting the appellants to approach the concerned police authority with proper application for removal of certain belongings which are stated to be left behind by the appellant in the said premises. There is a grievance expressed by the appellant that despite such request made to the police on May 13, 2023, the request has not been acceded to. The court, while passing the order on 22/3/2023, has specifically said that removal of the belongings shall be with the consent of the writ petitioner / fifth respondent here. The first appellant is present in court, and the court queried him as to whether he is willing to explore a possibility of settlement of the entire dispute by approaching the mediation center attached to this court. The first appellant has readily agreed to do so. The learned advocate appearing for the fifth respondent on instruction submits that his client is also ready and willing to explore the possibility of settlement through mediation. In the light of the above, we refer this matter to the mediation center attached to this court for initiating a mediation process and to examine as to whether reasonable solution can be arrived at between the parties. Let report be submitted before this court on the next hearing.
My lord, in the meantime, my lord, police authorities may be directed to assist the petitioner
It will precipitate.
to take away the
Belongings.
certain belongings, my lord, essential
List the matter
documents.
on 30th June. Next.
My lord, that order may be directed to be complied with.
With
that.
the consent, mother won't give consent. Next.
Only your lordship pleasure to disturb, allow to disturb your lordship in the midst of a proceeding.
Father won't give consent.
What happened?
Well, yesterday, Mr. Dotto mentioned this matter, my lord, in respect of a matter of justice.
Yes, already arrangement was made.
I went to mention there. His lordship has opined in court that you go to the Honorable Chief Justice because today there is such a pressure, I cannot take up this matter.
You move the first vacation court. Nothing will happen between today and
The
that's what-
urgency, my lord probably has looked to the order. The urgency is any day I am apprehending.
I have gone through the order.
Any day you are apprehending.
Nothing will happen in these 2 days. We will grant you leave to move the vacation. In fact, we told that to Mr. Dattu. Please.
But his
There are a
lordship,
lot of other work to done, sir.
they are lordships, they are lordships of the view that today we cannot take up because of the pressure.
Because all of you are going to be busy after 2 p.m. Nobody will be free today. Lordship also will not be free today.
No, but situation is this, my lord, this is
Nothing.
for the client's problem. We are,
Nothing will happen.
my lord, if you lordship take up, my lord, the other side is, if my counsel is here, my lord, if this assurance may be given, the next 2 days, nothing will happen, then
That we can't.
that's why my lord, we apprehensive.
So because we don't have determination on that, we will grant you liberty to move. You just circulate, let the council circulate a letter. We will say liberty to move the. I'll make an endorsement.
That court will make grant.
They will do it. They'll.
So that court had determination. We are only apprehensive, my lord, that if something happens within 2 days, my lord,
No,
it
nothing.
appears, my lord, the order is such.
You know how to advise what if in case something happens. Yes, sir. Sorry.
Serial number 5. Lord, sorry to disturb your lordship, Lord, on the last day before the vacation. But Lord, certain exigencies of the situation has compelled us to mention the matter before
This
your
is that
that underpass, Lord,
some
contract was terminated. Lordship felt, Lord, when the matter was being heard, that if something can be worked out, because apparently, Lord, your lordship was of the view that something should be done. But Lord, the matter was taken up on 3rd of May.
Yes.
Lord, on 3rd of May, this was observed, and this is the order that your lordship passed. Lord, kindly, Lord, see the supplementary affidavit we have just brought on these on record these facts. Page 22, if your lordships kindly come to. This was the order that your lordship was pleased to pass
Yes, we saw
on
that.
3rd of May.
Hmm.
And Lord, then the next page, your lordships will find there is a fresh tender, which is, Lord, uploaded on the 15th of May. This starts at page 23. Please come to page 25.
It says 27/4/2023.
It says at the top, but Lord, please come to 25. As on that date, Lord, they did not mention that they are contemplating to issue a fresh tender. Page 25, it says date of uploading, has your lordship found that?
15/5.
This is how we have come to know. Now, Lord, this is uploaded. This is the tender which is floated. And Lord, 30th is the date for bid submission, and 1st is the date of opening the bid. Lord, if this goes through, then Lord, our appeal becomes totally infructuous. That was not the intention of your lordships, Lord, when my lords heard the matter. Lord, may I just tell your lordship, Lord, we had challenged the termination on the ground that it was arbitrary. Because, Lord, this is not a dispute arising out of the contract. Learned judge, my lord, mistook it to be a dispute arising out of the contract and said that this will be remedies under private law remedy. Now, Lord, it's a series of judgments, Lord, which we had cited, that, Lord, if the decision to terminate is arbitrary, then, Lord, this is amenable to
What we can observe is, without prejudice to your rights in the appeal, you participate in the C tender.
Yes, Lord, if I do that, Lord, that will be the end of the story. Lord, I was seeking this protection, that your lordships will kindly, Lord, stay the tendering process and kindly hear it up, Lord, after the vacation.
We will hear it up. Probably we can say that the any proceedings pursuant to the e-tender floated on 27/4/2023, uploaded on 15, will abide by the further orders in this.
So let them not allot the contract. That is what I'm saying. Let them not, Lord, allot the contract.
Let them participate, my lord.
Lord,
Let it be a-
if they participate, Lord, then all our rights are gone. Lord, we are, our content.
No, your appeal is pending. We
Lord, our
consider-
appeal
Lord,
is pending.
prejudice, they can
Kindly,
participate.
Lord, see the termination
So,
letter one.
Without prejudice to your rights, you please participate. in the
Lord,
tender.
kindly come to page 254. Kindly, Lord, see what is the
Stay there.
grounds of cancellation.
30th of May.
Lord, I have paid the entire license fee. My
So what we
contracts.
can do is.
Yes.
You have brought this on record today.
Yes,
You please give him a copy.
we have served.
We will list the matter in the first vacation court. You pray for it, but you need to file an application for appropriate interim orders.
Lord, can I say, Lord, your lordships have not, Lord, rejected my prayer for interim order. Your lordships, Lord, were hearing
No,
the.
that was on a different cause of action. That arose out of a
Lord,
challenge.
if I succeed in getting a stay
No,
there.
no, this is an entirely different proceeding. Third party interests may come in. Some people will say, I want to participate in the tender. So therefore, we will give you liberty to move an application which can be listed before the first vacation.
Lord, to avoid multiplicity of proceedings, may I pray for this? Lord, the first stop of work was on the ground that there is a transfer from KMDA to KMC.
That we remember.
Now
In fact, we have flagged all those.
Correct. And your lordships will find, Lord, from the notice that has been issued, fresh tender, it is by KMDA. So, Lord, that ground goes. The other grounds were with regard to technical fault, non-specific and not well defined. Contract being not, these are the three grounds at page 254, your lordships will find.
To be notified. We have
Lord-
heard so and so.
Lord,
The learned senior advocate appearing for the appellant submitted that during the pendency of this appeal, the KMDA has issued a fresh e-tender notification dated 27/4/2023, which has been uploaded on 15/5/2023. This has been brought on record by way of a supplementary affidavit. If the appellant is of the view that the fresh e-tender process should not proceed further, then an appropriate application for such a relief should have been filed. However, we grant liberty to the appellant to file such application if so advised, and if such application is filed, the appellant is at liberty to move the vacation court. Vacation.
Can I
Grateful.
just make one humble submission?
Yes.
Lord, on the 4th of May, when your lordship were hearing this matter, 3rd of May, Lord, your lordship was of the view that, Lord, they should not come out with a solution.
But
That was the ground, Lord,
now that the e-tender has been uploaded, it goes without saying that
Lord,
there
they
is
have gone against the trust of the court. This is, Lord, what I wanted to point out.
Alright, then we can do one thing, we can release the matter.
Lord, kindly do not release. That will put my client into
File a
more
can-
difficulty.
You file a CAN application, definitely it will be listed in the vacation.
Lord, kindly, Lord, fix this matter, Lord, immediately after the vacation.
yeah.
Because, Lord, I want to press my application, Lord.
Please. Let the appeal be listed on 9th June.
Wait for me.
Next.
Serial number 6. Seek my lord's kind indulgence.
Yes. What happened?
Yes.
Mr. Banerjee is here, my lord.
Sir, they are saying that police is not cooperating. Why?
That is not my submission. Manas, police is not cooperating, not because of the Manas police only we have not been able to take the custody.
So no
This is the surprising
State is-
problem, these people think that immediately, no, one second. The police will jump in immediately, arrest everybody and take. But there we have to follow the process of law.
My lord,
And
what
first we
happened-
try to persuade, but they make these submissions
Sir,
that are very reckless.
after taking the custody of the horses, my lord, we have been, my lord, threatened by the owners of the horses with dire consequences, my lord.
Let them
That
lodge
is,
it.
that
If
is,
they
my
have-
lord, my apprehension, my lord, only, my lord, if the, my lord, police may be directed to, my lord, to guard the sanctuary where the horses are not.
Then at least you give some protection.
Yes,
because
only to that extent.
they are implementing a court order. Your state is assisting. So it's unfortunately considering the level of education, etc. of these horse owners, it's very difficult to reason out to them.
Yes, my lord.
That's no, but
That's the-
surprisingly, I'll tell you, we are very lucky in this case. When they came for the meeting, honestly, I was not so positive. But suddenly some of them agreed. So it was a very refreshing situation. So that But what happened is there's a one particular mischief monger has gone into
Yes,
the
my lord.
situation.
That
He's the one who created all the mischief yesterday. I've got the entire instruction of what happened yesterday. It went on for throughout the day that these people, he started pursuing.
What we will say is that what is it? The police, the state police shall ensure that the order and direction issued by this court earlier is scrupulously complied with, and the police will be entitled to take action if suppose somebody does any action to interdict the implementation.
May I just
And the organization which is organizing for transportation of the horses be given adequate protection.
the only thing I was praying, Lord, if they indicate which police station is there, that
Rajarat, so far as our sanctuary is concerned, my lord, it is situated under Rajarat police
It's
station.
not listed, no. It is not on board today.
Yes, my lord, it was on board yesterday, my lord.
You can bring it as days.
5384. So now, by consent of the parties, your lordship can treat it on the days
Yes,
list.
my lord.
I don't have a problem. Lord,
we
only
have
thing
heard-
that your lordship will direct the Rajarat police station, which is under the Bidhannagar commissionerate, to
You
render.
please write
Yes,
down.
I shall give it to you. Lord.
Please, sir.
Yes, ma'am.
Chatterjee,
Rajarat police station,
you
Rajarat
have
police
heard
station.
the advocates for the parties.
Sure.
Pursuant to the directions issued earlier, 8 horses,
You know,
8 or 9, how many horses have
Nine we have gotten.
Huh?
my lord, 9 out
9
of 16, my
horses
lord,
have
9.
been rescued by the NGO, and they have been transported in special trucks to a place where they will be given adequate treatment for rehabilitated.
Bidhannagar police station.
The learned advocate appearing for the said NGO submitted that the persons who were involved in the transportation of the horses were threatened,
Case number.
and the trucks were also sought to be blocked. We direct the so-and-so police
Yes,
to ensure that the persons concerned with the NGOs are given adequate protection, and the trucks which are transporting the horses should also be escorted in such a manner that the horses are taken to the place.
No, it is already gone there.
9 of them are already.
Nine of them are already gone, my lord.
Such a manner that the trucks reach the destination in a safe manner, in a safe way. Full stop. It is submitted that in respect of the 9 horses, they have already been transported, and it appears that only one person is not cooperating and is creating a certain nuisance. The concerned police is directed to identify the said person and advise him that he has to comply with the order passed by this court, failing which he will be liable for deterrent action. The other departments of the state shall also provide necessary
But only one
assistance.
prayer I was saying. Yesterday, one of the main problems that we faced was the ramp which was taken over there to the Maidan area, that was broken. So as a result, for more than 6 hours, 5-6 hours, when we are trying to persuade this side and then the ramp is broken, we were immediately trying to have they should not ensure the proper infrastructure facilities there.
Assistance for the effective implementation of the directions issued by this court earlier. It is submitted by the learned advocate for the state that the ramp which was provided for for putting the horses into the trucks.
Ramp was below the ramp for
Was
6
broken.
hours. It was delayed.
The concerned NGO is directed to
Then what
ensure
happened? What did you
that
see? The ramp was not broken.
proper ramps are provided so that the remaining horses can also be safely transported to the place in question.
But I am just told, my lord, there is more than one person who is, my lord, creating, my lord, nuisance, my lord.
One of them has
Your
been
lordship recorded-
identified and FIR also we have lodged against before the Maidan police station.
This is enough, sir.
But as regards to the other 7 horses, my lord, endeavor has been made, my lord, so they can also be rescued
Yes,
and put in.
My lord, may I only pray for obtaining a plain copy of the order, my lord?
Pardon?
May I pray for obtaining the plain copy of the order, my lord? The
Plain copy. No, what we'll do is If you go and contact registrar IT, they will give you a, they'll pull out a copy from the server.
Register ID.
Regis-
I'm grateful, my lord, grateful.
That's all.
IT.
Written
That's
on
right.
date, same date. In the earlier order, whatever.
Oh, sorry.
Yes.
If your lordship kindly permits, Lord, so far as the liberty to move the vacation bench, we need a plain copy of your lordship's order because the server being down.
No, no.
Unless we have a copy.
Server is down in the sense you can't access it. But if you go to the registrar IT, they'll be able to, they'll give you a
Registrar,
registrar IT.
IT. Lord, can kindly give a liberty so that, Lord, they can.
Yes, yes, yes. That we have already, I have already instructed.
Oh,
Yesterday also couple of orders, this appeal which Mr. Sanyal mentioned, there also.
Oh, I see. So they will,
That,
Lord, the other thing is, Lord, kindly indicate that, Lord, steps taken in the matter shall abide by the result of the appeal. That observation
everything
perhaps,
is there, sir. We'll
Lord,
take care.
that observation was not there by your.
It is not there. Initially, we offered that observation. We
But
did-
I thought, Lord, I didn't think that I'll get disentitled to get,
No,
pray for that.
No, that you have brought it on record. You bring in a proper application. In that application, that order can be.
Lord, kindly, Lord, make it clear because otherwise vacation bench is always a matter of chance, your Lord.
No.
Kindly, Lord, protect us, Lord. We are appealing.
Nothing will happen. Nothing will happen. You bring that, you file a CAN application, it will be heard. Yes, please call the next case.
Appellate side released serial number 6.
Yes.
May I please, my lords? Sure. I appeal for the appellant SSC, my lords. I have filed this inter-court appeal against an order passed by the learned single judge on 8th of December 2022. My lords, there is a delay of 59 days.
That is all right.
Yes.
What was challenged? You
So-
challenged your show cause notice.
No, my lords. So, my lords, basically the show cause notice is a consequence of a norms committee decision which is constituted by the DGFT. So, my lords, I'll just briefly take a couple of minutes to explain my matter, my lords. I am engaged in the manufacture of de-oiled rice bran. De-oiled rice bran, my lords, is manufactured from rice bran, and in the process of manufacture of de-oiled rice bran oil also is generated. Now, my lords, I had so in this is a matter pertaining to the foreign trade policy. In terms of chapter 4 of the foreign trade policy 2015-20, my lords, I can make an application for advance authorization, which allows me to import goods without payment of customs duty in two cases. Either if a standard input output norms is prescribed for that particular product. If it is not prescribed, then I can do it on a self-declaration basis. That is permitted in terms of the policy, not in dispute. Now, my lords, when it is done on the self-declaration basis, my lords, in that event, there is a norms committee which is by the DGFT, which will fix the standard input output norm for the product against which I am making that application. Now, my lords, I had made this application. I had applied for the issuance of advance authorization on self-declaration basis for import of rice bran, which is for which CON is not prescribed and which is also not in dispute. Because I had made this application in terms of para 4.07 of Handbook of Volume Procedures, so therefore this was required to be ratified by the Norms Committee. When I went to the Norms Committee says that because it is not possible for you to fulfill the value addition criteria prescribed in the foreign trade policy, so therefore I am rejecting. Normally, its value addition has been described in the foreign trade policy. A formula has been prescribed. Basically, it is, if I just put it very simply, it is value of export minus value of import divided by value of import. That is the formula. Now, let's applying that formula, I can establish, or in fact, I have established on record that I have fulfilled the value addition criteria. Now, because my application for fixation of norms was rejected, the customs relying on this norms committee order has issued a consequential show cause notice demanding customs duty. And after filing of my petition, this show cause notice was adjudicated, order was passed, and in light of the time limit for preferring an appeal, I was constrained to file an appeal also. Now, before the learned single judge, my petition was dismissed solely on the ground that the show cause notice has culminated into order and against which I have preferred an appeal. But the fact of the matter, my lords, is I'm principally aggrieved by the norms committee decision because it
But
is,
norms committee decision is an appealable decision.
no, my lord. So I have preferred review.
No, if the norms committee under the Foreign
Foreign-
Trade Development
Yes, ma'am.
Act and regulations.
Yes.
It can go before the DG.
So for which I have made an
The
application.
DG, he constitutes a committee
Yes.
and that committee will decide. See, these are all matters which are clearly outside the purview of a writ jurisdiction.
My lords, I completely agree. My lords, I am not even asking my lords to decide on the merits. My lords cannot decide because it is a matter of technical expertise. What I'm just saying, my lords, I would just like to bring one aspect to your my lords notice is the fact that while norms committee says that I could not have fulfilled the value addition criteria, that is the only basis of rejecting my application for fixation of norms. The customs in their show cause notice, they have admitted that I have fulfilled the value addition criteria, albeit using domestically sourced inputs, which is not prohibited in terms of the foreign trade policy. In fact, foreign trade policy.
But why did you not place this material before the
I have
norms?
placed everything before the norms
But
committee.
the norms committee decision you need to challenge.
My lords, which is what I've challenged.
No, not before the writ court.
Yes, my lords. So my lords, kindly come to my prayer portion.
Where is the decision of the norms committee?
My lords, it is at page number 253, my lords. First volume, my lords. And my case is, my lords, at page number 254 at the bottom. My lords, is there at page 254?
Yes.
My lords, at the bottom, case number M179.
PK agree.
PK agree.
PK agree.
So, my lords, this is my case, and the decision is at page 255, my lords. May I read it for my lords? Decision.
Yes, yes.
Norms committee considered the case as per the agenda and noted that the firm has imported rice bran and hexane for export of de-oiled rice bran. Against the above mentioned 3 advance authorizations, the committee had rejected the case in M number 1685 dated 27 December 2018 with the view that value addition of 15% or more shown in the advance authorization is technically not feasible after oil extraction from the duty-free rice bran. So, my lords, it has been assumed that I can't meet the value addition criteria. Now, my lords, I would just like to take you through the custom show cause notice, which admits.
No. As against the minutes of the meeting of
Yes.
the committee,
Yes, my lords.
it should fructify into an order.
My lords, so this is published on the DGFT website. No order is passed pursuant to this.
No. What is the remedy available to you?
There is no remedy except for review. So, my lords, I can file a review application, which I have done.
We will direct the review to be heard.
So, my lords, this order has been passed in a review application, which is before my lords. So, which is why, my lords, my humble submission is that, of course, I completely agree that my lords cannot decide this issue. But let the norms committee reconsider its decision.
No. You just check up under the Foreign Trade Development Act.
Yes, my lord.
Definitely there is a.
So, my lords, there is an appellate provision under the Foreign Trade Development and Regulation Act that is against an order passed by the DGFT. Now, the problem is that this norms committee is just ratified by the DGFT. It is published on the DGFT website.
It is deemed to be a decision of DGFT.
Yes, my lords. This is deemed to be a decision.
So,
yes.
therefore, you file an appeal against.
There is no appeal, my lords.
Any person aggrieved by any decision or order made by the adjudicating authority under this act may prefer an appeal where decision or order has been made by the Director General to the central government, where a decision or order has been made by an officer subordinate to the Director General or to the Director or the officer so and so.
Yes. So, my lord, the
superior to the adjudicating authority 45 days.
The adjudication order also, my lords, has been defined in the foreign trade policy. It says that an order which seeks to impose penalty, and that is through a separate notice which has been issued by the DGFT to me, which is also under challenge, my lords, and which is not culminated into any order so far.
No, it says where against any decision or order. So if this is taken as a decision, then obviously you are entitled for an appellate remedy.
My lord, but the definition of adjudication order says that which seeks to impose a penalty.
Where is the definition of adjudication? Only order has been defined. Order means an order made by the central government under section 3.
There are judgments also, my lord, on this code that any decision or order.
Any decision,
Yes, my lord.
any decision, this shall be a decision of in the ministry, there is this Sion norms, always it has to be resolved by an expert body.
Yes, ma'am.
And definitely there is a remedy. My recollection is that there is a remedy, and the central government constitutes a committee, and that committee will examine as to, because according to you, the show cause notice, this particular thing has been accepted by the customs authorities.
No, my lord, show cause notice says that I have fulfilled.
Value
the-
addition.
So basically, my lords, here the entire bone of contention is the value addition criteria. Now,
But
show cause
From
notice,
2019, you have not done
my
anything.
lords, I have been continuously filing a review application before the norms committee.
When
So
already, where is the latest review? Of
latest is this one, my lords.
No, that is already decided.
This is decided. I came to the writ court dismissed my
This
petition.
was decided, Rahul. This was sometime in 2019.
Yes, my lords.
And you came in 2023.
My lords, I came before the writ.
After you faced the show cause notice.
No, my lords. Show cause notice was also part of the writ petition.
No, my lord.
I had filed the petition in 2019, my lords.
The first review was challenged by him.
Yes.
Before this court. Thereafter, liberty was given to him to go back,
Yes.
and thereafter this review was.
Yes. So this is the
adjudicated,
fourth
and
round
then-
before the norms committee itself, my lords. It is not that I've come approach the writ court directly.
No.
But from
You-
2019, that is.
You
correct.
examine it, we'll keep it after vacation.
My lords.
You try to bring it
My lords.
within the ambit of
Yes, my
section
lords.
50.
I'll definitely try. My lords.
And you check up, there are
I-
regulations which say that there is a high level committee where secretaries to the government are there and technical experts are also there. Each industry has got a,
Right, my lord. So norms committee contains that expert. And
because there should be an agricultural expert here.
which was considered in one norms committee. They have referred to the food ministry's statement or remarks to submission to say that you could have allowed a fixation of norms at a particular ratio. But in spite of that, norms, my application for fixation of norms has been rejected.
And what happened to your appeal before the Commission of Appeals?
My lords, now that has also been adjudicated in spite of me writing. So my lords, actually I'm running two parallel proceedings. One under DGFT for fixation of norms, because ultimately the customs proceedings are entirely dependent on this.
Obviously,
Has to be.
see, unless and until this norms committee decision is set aside,
Yes,
they will not keep quiet.
Yes,
They will
absolutely,
proceed
my lord.
further.
Absolutely.
My lord,
Absolutely.
today he has come before my lord after the adjudication proceedings. It's not that he has come at the time of show cause proceedings.
No, I've
He has
come.
come after the
No, my-
adjudication.
No, after the show cause was
No, my lord, that
issued
is,
in 2020,
that is not a correct submission, because when I had filed the writ petition, by then the order had not been.
adjudicated.
No,
Case has not been,
my lord, kindly.
because order in original was only on 31st
Absolutely,
of
my lord. So
August.
that is certainly not the
2021,
case.
after the writ
Yes,
petition.
my lord, certainly.
And as against this order, he has filed an appeal before the Commission of Appeals.
Because
But Commission of Appeals can't do anything.
nobody can do, my lords. That is my predicament, which is why I've come before my lords. Kindly remit me back to the norms committee. I don't have any difficulty, my lords.
But then it's a fourth remand is of no use.
Is of no use with certain guidelines, considering the observation even of the customs
No,
department.
my lord will then hear me before passing such an order.
Yes.
My lord,
We'll keep it up. We have heard Mr. Rahul Dhanuka, Mr. Vipul Kundali, etc.
I'm appealing for the DGFT, my lord.
The first question to be decided in the instant case is whether the appellant has got any other alternate remedy to question the correctness of the norms committee, question the correctness of the decision of the norms committee constituted by the Directorate General of Foreign Trade. Prime facie, we are of the view that an appeal is maintainable in terms of section 15 of the Foreign Trade within bracket Development and Regulation Act, Development Regulation bracket close Act 1992. As subsection 1 of section 15 states that any person aggrieved by any decision or order made by the adjudicating authority under the said act may prefer an appeal before the authority mentioned in clauses A and B of subsection 1 of section 15. The question would be whether the minutes of the norms committee of DGFT could be construed as a decision. And if it is so, whether if it is so, which should be the appropriate appellate authority before whom the appellant can put forth their contentions. We are conscious of the fact that the decision of the norms committee is a technical matter, and the court the court exercising jurisdiction under Article 226 of the Constitution can examine the decision-making process, but not the decision itself. On account of the findings recorded by the norms committee, the customs authorities have issued show cause notice on 8/10/2020, which notice was adjudicated, and an order in original dated 31/8/2021 has been passed. As against the said order, the appellant has filed an appeal before the Commission of Customs within bracket appeals within Kolkata, and the appeal is pending.
No, my lords, even the appeal stands disposed, my lords. Order in appeal is at page number 355, my lords. It is appeal dated 24th.
And the appeal was dismissed by the first appellate authority by order dated
before the tribunal. 24/4/2023.
24/4/2022. As against the said order, the appellant has filed an appeal before the tribunal, and the matter is pending.
I have not yet filed, my lords. My remedy lies.
The appellant is in the process of filing an appeal before the tribunal. Thus, the appellant has to satisfy this court that as to whether the decision of the DGFT is not an appealable order, and that the writ remedy is the appropriate remedy. We grant time to the learned advocate for the appellant to make submissions on the aforementioned issues on the next hearing.
Is my lords condoning the delay of 59 days?
That I'll condone. You can do one thing.
Yes.
You challenge the decision of the norms committee before the tribunal. You raise grounds. Tribunal, being a fact-finding authority, will be entitled to do. But whether DGFT is a party before the tribunal?
No, my lords.
No, they haven't gone before the tribunal.
I have not gone, and my lords.
My lord is giving good advice.
My lords.
That's the only method.
The only difficulty which I, in my humble submission, I foresee is that whether tribunal being a creature of the a particular act.
No, probably you need to convince the tribunal saying that the customs authority's action is consequent upon decision of DGFT. So therefore, if I need to contest the show cause notice and order in original, I need to contest the decision of the DGFT. So please consider whether DGFT's decision was just and proper. So they can say export was not there, this was not there. But my recollection is there is a committee consisting, headed by a secretary to the
Appellate commission, like the earlier times, appellate commission was there. Similarly, it is there.
I'll check that.
And I think that committee will also have an industrial representative. Industry representative.
My lords, what my lords is saying is norms committee, exactly if you see the constitution, it exactly constitutes of all these members actually. So they have
people in your trade also will be represented.
Yes, so that is precisely the
So in fact,
constitution.
the entire DGFT notifications or regulations are all based,
Yes.
what is it, trade friendly.
Trade friendly. Yes, yes, my lords. Yes, my lords. Absolutely.
And once my lord goes into this matter, we'll find out that what my learned friend is saying, that customs has said that value addition is correct. That is a difficult
Let give some date in the second or third week of June.
My lord, after 19th June.
After 19th, any date.
We will.
23rd June. Grateful. Much obliged.
Grateful to your honor.
Serial number 7.
Yes, sir.
My lord, appeal against refusal. Well, I really wouldn't say refusal. My lord, interim order. My lord, we succeeded in, my lord, convincing the learned single judge that we made out a prima facie case.
Admission.
But, my lord, the interim order was in the nature something which went against us. The interim order was in favor of the revenue. Well, I'll tell your lordship briefly, if I may just tell your lordship the facts.
Yes.
My lord, I am the customs broker. My lord, dry dates were imported. So my lord, and thereafter it was released for home consumption out of charge, released for home consumption. My lord, thereafter, my lord, a show cause notice is issued to the custom broker, which was the writ petition and the appellant before your lordship, my lord, for wrongly availing IGST, exemption under IGST. So, my lord, the customs proper officer under section 28 of the Customs Act gives the custom broker a show cause notice for allegedly incorrectly availing of exemption under the IGST.
But you are one of the notices. The importer is the
Importer
main,
is separate.
is the main notice.
Correct. So, my lord, what we are respectfully submitting before the lordship now, if your lordship will take the impugned order, my lord, we prima facie convince the learned judge that, my lord, for the purpose of exemption of IGST, a proper officer under the Customs Act has no authority. Because section 2 subsection 50 defines duty, and imported goods specifically says that once it is released for home consumption, it ceases to be an imported goods. And recovery of IGST, even if I assume for the sake of argument that
No, the learned judge says,
yes,
I am also of the view that the petitioner has been able to make out a prima facie case in this matter for an interim order.
yes, and then tells the authority whose jurisdiction I say is he inherently lacks jurisdiction because under the Customs Act he could not have issued, says
But
that he will decide.
Mr. Bhattacharjee, please come to page 57.
Yes, I have seen, my lord. I have seen. My lord,
And have you filed your affidavit?
No,
You file it
yes.
within 3 weeks, 4
My
weeks?
lord, one thing I
See,
lost,
this is a very important, good point. No? You need to answer.
my lord, one thing I lost to tell you.
28(1) and 124, can you invoke whether he is a proper officer? And secondly, unless you fix this man, that he was responsible for some wrongful declaration.
No, my lord, even your lordship's judgment is there of the Madras High Court. We've taken it out. Misdeclaration. My lord, giving an incorrect classification. It was a classification issue. He says that you have availed of the IGST exemption by giving an incorrect classification. It should be soft date, you've given dry date. So, my lord, even assuming
Which is the country of origin goods?
UAE, United Arab Emirates. So, my lord, even incorrect classification in a bill of entry does not amount to misdeclaration. Well, there's peculiar judgment is there.
No, how do you hold the
Northern Plastic, your
customs
lordship has followed.
broker responsible? That's the issue.
My lord, your lordship, the custom broker is now before your lordship.
Hmm.
The SSC doesn't, my lord, challenge.
No,
the
importer
file
has
application,
not
my lord.
Let-
Broker
let-
has not been challenged.
no,
by-
you adjudicate the show cause notice as against the importer.
Now, my lord, now I am coming to the next point. Custom broker, my lord, acted as an agent of the SSC, my lord. Kindly appreciate here. My lord, as per, my lord, section 5, subsection 1 of the Customs Act, my lord. If you're, sorry, my lord.
Section?
Section 5. Subsection 1. IGST. My lord, section 5, my lord, of the IGST Act provides so, if your lordship kindly takes, may I read, my lord? Provided that the integrated tax on goods imported into India shall be levied and collected in accordance to the provisions of section 3 of the Customs Tariff Act on the value as determined under the said act at the point when the duties of customs are levied on the said goods under section 12 of the Customs Act. Therefore, my lord, an assessee, my lord, who imported the goods here, if he is liable to pay by the IGST duty, my lord, the customs authority, my lord, has a authority to collect it. If he got the exemption here, my lord, then my question put to me, my lord, who will collect the tax, my lord, from him? Who he has got the exemption? Then who is the authority, my lord?
See,
It was on audit or
How do
during
you-
audit, it has been found.
under the CBLR, if he has committed a mistake, you proceed.
My lord, then appeal is, then my appeal is there. He can prefer an appeal with the customs
All right.
commissioner appeal.
We have
My lord, kindly appreciate, my lord.
All right, we have heard Mr. Mainak Bose, learned advocate, appearing for the appellant, and Mr. Udeshankar Bhattacharjee, assisted by Mr. Tapan Banjal, and standing counsel for the respondent. The appellant is before this court challenging the order passed by the learned single bench dated 2/5/2023. Particularly with regard to the directions given in the last paragraph of the order, whereby the appellant has been directed to file a reply to the show cause notice which was impugned in the writ petition, and time for filing such a reply was extended. However, we find from page 2 of the order, the Hon'ble the learned writ court has recorded the following finding. Following prima facie finding, page 57, I marked in pencil. A reading of the above paragraph will show that the learned writ court was prima facie satisfied that the writ petition cannot be thrown out at the motion stage, and the issue involved deserves adjudication upon affidavits to be filed by the respondents. Further, the court was of the view that the appellant has been able to make out a prima facie case in the matter for an interim order. The court, having come to such a conclusion, had issued a direction to the appellant to submit his reply to the show cause notice. In our view, if such direction is to be implemented, the writ petition itself would become infructuous. More so when the learned writ court was of the view that the writ petition cannot be thrown out at the motion stage, and the issue involved in the writ petition deserves adjudication, and the writ petitioner has also been able to make out a prima facie case for an interim order. Therefore, we are of the furthermore, the learned writ court had noted that the question of jurisdiction of the respondent officer concerned and the interpretation of several provisions of law are involved, and also several decisions of the High Court are required to be considered. Therefore, we are of the view that the adjudication of the show cause notice should remain stayed till further orders are passed by the learned writ court after affidavits are filed by the respondents. Accordingly, there will be an order of the order restraining the respondent from proceeding with the adjudication of the show cause notice dated 16th February 2023, and this order shall be confined only to the appellant and not to the other core notices. With the above observation, the appeal stands disposed of.
My lord, kindly make an observation of the author. Department will adjudicate the, my lord, so cause notice in respect of the.
Yes, that
Kindly make a one sentence.
no, that we have said. This order is only for him, not for the other core notices. Next.
Serial number 8.
Yes.
My lord, the thing is only the stay application was filed yesterday. I could not effect service well, and it was made returnable after vacation. My lord, the matter is relating, my lord. A very simple issue is involved, my lord. My lord, I had my lord, the order under section 148 AD was passed, and I challenged the order before this honorable court, my lord. And during the pendency of the writ petition, my lord, the assessment order was passed. My lord, I had played
You didn't get any interim order in that.
no, my lord, I did not get any interim order, my lord. I had prayed for liberty to withdraw the writ petition with liberty to file afresh, my lord. That liberty was denied to me. This is the pith and substance of this.
So you want to withdraw the writ petition and file a fresh writ petition?
Yes, my lord.
Challenging both orders.
Challenging both the orders, my lord, the assessment order also.
Sir,
for this.
we have already held that the assessee has no other remedy to question the correctness of a 148 AD order. It can't be done at the assessment stage, nor in an appeal arising out of an order of assessment. Therefore, that liberty we will give it for.
Liberty, if my lord wants to give, I am not a person to stand in the way.
All right. We have heard so and so. The learned advocate appearing for the appellant seeks leave to withdraw this appeal as well as the writ petition with liberty to file a fresh writ petition challenging The order passed under section 148 capital A within bracket small d of the Income Tax Act 1961, as well as the assessment order dated 31/3/2023, passed under section 147 of the Act. The appeal as well as the writ petition are dismissed as withdrawn, with liberty to the appellant to challenge both the aforementioned orders. Next.
Serial number 9 to 11. My lord, only one thing, since we have not received a copy of the.
Well, I'm just handing over a copy.
Yes.
My lord, these three, my lord, are, my lord, connected appeals. My lord, a very short point, my lord, is involved here. And may I indicate that to your lordships? My lord, a very unfortunate incident, my lord, of a student, my lord, of IIT Kharagpur. My lord, it relates to his death. My lord, it was being investigated by the police. My lord, a writ petition had been filed saying that a special investigating team should be appointed for the purposes of this investigation.
Yes.
My lord, this was, my lord, these were the prayers. Now, my lord, from time to time, my lord, reports, my lord, were filed with regard to the investigation, my lord, by the police. My lord, I am only troubling your lordships, my lord, with the police aspect. My lord, there were other directions, my lord, for IIT to file reports regarding ragging, etc. I'm, my lord, not going into that. Now, my lord, the police, my lord, was, my lord, filing reports. My lord, none of the reports were found, my lord, unsatisfactory by the learned judge. My lord, this is, my lord, very important. But, my lord, just before, my lord, a report was filed on 20th of February 2023, my lord, almost, my lord, at the stage of final report. Once this is filed, the learned judge, and that's there are three appeals, the learned judge, my lord, appointed a person, my lord, who is no longer, my lord, in the police to give his opinion, my lord, with regard to the investigation. This is 20th February 2023. Then, my lord, after that, my lord, files were made over. My lord, opinion, yes, opinion, my lord. I advised you don't need to go up now. Writ is still pending. What happens, my lord, is, my lord, the gentleman comes and says, I've had a look at the records. I feel that there should be a second postmortem report. So, my lord, an application, my lord, is made. My lord, in, my lord, that application, my lord, liberty is given, my lord, to make that application. So, my lord, now an expert, my lord, is, my lord, taking over the investigation, who is a private, my lord, entity. Third order, my lord, which has been passed is, my lord, that, my lord, the body would be exhumed. The post-mortem will be done, my lord, by this expert. And, my lord, he will, my lord, file a report. And the learned judge says, my lord, the order should not be taken, my lord, as, my lord, any, my lord, kind of adverse, my lord, remark, my lord, apropos, my lord, the police. So, my lord, there is, my lord, no aspersion, my lord, on, my lord, the investigation which has been carried on. Now, my lord, I make, my lord, one simple submission before your lordship. My lord, in, my lord, criminal investigation, neither the statutory framework nor, my lord, public policy permits, my lord, a private investigation. My lord, I can understand, my lord, a sit is appointed if the investigation is not being carried on properly. I can understand that. But, my lord, the investigator, my lord, the expert, my lord, becomes the investigator with, my lord, a report, my lord, to be filed without any aspersion, my lord, on the police. My lord, is not possible. And in any event, private investigation is not possible. My lord, I waited long to, my lord, because writ was pending. There were no final orders. But, my lord, this step, my lord, could not have been taken. My lord, kindly take, my lord, my lord, three orders. Kindly take the second writ, my lord, in your lordship's wrist. My lord, they are arranged one by one. My lord, that is, my lord, MAT 850, my lord.
This is previous one.
My lord, they are arranged one by one, my lord. Your lordship kindly comes to page 245. My lord, in fact, my lord, I was a late entrant in the matter. The learned judge wanted me during the course of the hearing, my lord, to come in. And then, my lord, I come in, I file the report. Kindly have a look, my lord, at page 245.
Yes.
So and so has placed the report of the investigating officer dated February 20 without expressing any opinion on the report as on date. This court is of the view that the post-mortem report, forensic examination report, and the entire case diary along with the photographs and every piece of evidence may be placed before Dr. Ajay Kumar Gupta, a retired forensic expert from the CID West Bengal, for his opinion on the likely cause of death of the victim. Mr. Gupta shall be provided. I declare, my lord, the rest are, my lord.
But this writ petition was filed by the father of the victim.
Yes, my lord.
Or the deceased.
Father, my lord.
Father of the deceased. And their prayer was to conduct a second postmortem.
No. The prayer, my lord, was, my lord, kindly appoint a special investigation team. Second postmortem, my lord, comes, my lord, after, my lord, this gentleman, my lord, Dr. Ajay Kumar Gupta, my lord, files, my lord, an application. Now, my lord, kindly now come to.
By which order this Dr. Ajay Kumar Gupta was directed to,
my lord,
offer his opinion?
Yes. Now, my lord, he comes in here to offer his opinion. This order, my lord, 245.
Oh, that is you produced the report. That report was directed to be placed.
Correct. Everything, my lord. Post-mortem report, forensic examination report, entire case diary, along with photographs, every piece of evidence, maybe a retired forensics. My lord, case diary is not even available, my lord, to my lord victims and accused. My lord, under my lord, criminal procedure court.
But who is this person? He is a person of eminence, is it?
My lord, I do not, my lord, I have not heard of his name.
Because there have been orders passed. I'm also party to a few orders where there is one Professor Chandrasekhar. He is supposed to be the father of the forensic sciences. He is no more now. And he was the person who did the investigation in Rajiv Gandhi murder case. And after his retirement, he died at a ripe age of like 90 or so. Much after his retirement, lot of assignments were given by the government, governed by the High Court, and in the one case which was registered by CBI in Bombay, he was asked to.
My lord, government can, but I'll show your lordships two Supreme Court.
No, that is correct.
But I have learned that, my lord, he is a living legend. My lord, he has conducted more than 300 postmortems at the behest of CID, homicide.
No, what Advocate General says is,
I understand.
The writ petitioner does not suspect any foul play in the first postmortem. But then the court was seized of the matter.
He was all along, my lord, howling that it is murder, it is not suicide. That was what the main prayer in the writ petition. And the postmortem report, my lord, at page 93 here, is totally inconclusive because the body.
But, was the father present during the postmortem?
No, but the videography was taken. The videography was taken, and on basis of that.
Normally, in such type of matters, one of the relative of the deceased will be asked.
My lord, be informed, my lord. Information was, my lord, given.
And he was there. He was asked after he came to Kharagpur from Guwahati. The boy was a resident of Assam. The postmortem was conducted taking his consent. Taking his consent.
That entire video footage has been given to the
given to Dr. Gupta.
No, given to the writ petitioner.
No.
Should have been.
No, it was not. Now the second postmortem, the honorable judge.
See, the thing is, sir, if he is admittedly an expert and he retired from the government, state government service, to that extent he can consider.
My lord, your lordship,
but not that he will take over the investigation.
That's, my lord, this is, so that's what I'm showing. My lord,
that will not also be.
Absolutely. Now, my lord, I want to show your lordship. That's where it's gone. This was the first order. So, my lord, I didn't come immediately, my lord. I am saying, my lord, I've therefore preferred appeals from 3 orders to, my lord, show your lordships, my lord, how, my lord, this has happened. Now, my lord, kindly come to the second order, my lord, which is, my lord, passed, which is 29th March 2023, page 252.
Yes, there the court records that inadequate to arrive at a final conclusion.
Yes, and that was, my lord, also, my lord, as far as, my lord, the, my lord, police was concerned. My lord, this, as far as post-mortem, my lord, by itself, my lord, was concerned. My lord, this was, my lord, the stand, my lord, of, my lord, the police as well. So he agrees with the police. In substance, submits or seeks a second post-mortem after the body, let a preliminary report when the matter shall be listed. Then, my lord, kindly come to page 254. And this is, my lord, very crucial. My lord, I wish to, my lord, place this to show how investigation has been taken over. Dr. Ajay Kumar Gupta, the forensic expert appointed by this court, has submitted a preliminary report annexing therewith photographs from the footage of the postmortem already conducted by the police and come to 3 preliminary findings. Firstly, that there are 2 visible injury marks, otherwise medically called hematoma, on the back of the head of the victim, and the marks have been confirmed by Sandeep Kumar Bhattacharya, learned amicus curiae. Now, my lord, I pause here. My lord, this gentleman, my lord, had appeared for Dr. Gupta, my lord, which is recorded in the previous order, and now gets converted, my lord, into amicus curiae. Then, my lord, the original postmortem report does not mention the same. So this is a criticism, my lord, in, my lord, the opinion. Then, my lord, consequently, the base of the skull ought to have been examined and reported by the postmortem doctor, which has not been done. Then, my lord, the second important finding is that certain marks on the arms of the victim, Faizan Ahmed, according to Dr. Gupta, are clearly those inflicted after death. The postmortem report says these are antemortem by doctors, my lord, of, my lord, a government hospital, also reputed. Now, my lord, kindly come to, my lord, para 5. Mr. Bhattacharya has placed seizure report of the police dated 17, which indicates that a chemical called Emplura, sodium nitrate, in a bottle has been seized from the scene of the crime. It is submitted by Mr. Bhattacharya that sodium nitrate is a yellowish powder, is normally used to preserve meat. There is some yellowish residue in a bucket found by Dr. Gupta and Mr. Bhattacharya during his visit to the room. It is submitted that when a body decomposes, it is impossible that the fellow inmates of the hostel would not be able to detect it. There were mysteriously no smell from the body for 3 days. Presence of this chemical, Emplura, sodium nitrate, opens up serious questions as regards the time of death and whether it may have been used to preserve the body after the death of the victim. Photographs relevant to the annex finding are annexed to the report. Now, my lord, this is, my lord, his opinion, my lord, which is after, my lord, my lord, this getting, my lord, the having heard the learned counsel for the parties, this court is therefore of the view that a second postmortem is necessary. Fine. Now, my lord, kindly come. Body of the victim has been buried as per Muslim rites at Assam. Let the body of the victim, Faizan Ahmed, is ordered to be exhumed. An affidavit of the parents of the victim consenting to such exhumation and second postmortem has been filed in court. Today is taken on record. Then, my lord, the investigating officer in the matter shall coordinate with Assam police and ensure that the body and or remains are exhumed, brought to Kolkata by the state police, and fresh postmortem is conducted. It is expected that due care and caution is exercised while exhuming the body. The local courts in Assam are requested to kindly extend cooperation. Representatives of the parties may be present during. Now, my lord, kindly see here. The second postmortem may be conducted by Dr. Gupta in the presence of earlier postmortem doctors and anybody that the state may nominate from their side. Mr. Sandeep Kumar Bhattacharya, the advocate, may be present during postmortem. Then, my lord, postmortem may be conducted at the Kolkata Medical College and Hospital at College Street, Kolkata. Aforesaid exercise is vital and necessary for arriving at the truth behind death of Faizan Ahmed. Then, this order should not be construed as casting any aspersions on the state police, since they proceeded primarily on the postmortem report given to them. It is expected that the aforesaid exercise is conducted and completed with a period of 1 month from date. A forensic expert in the state of Assam may be requested to be present during the exhumation of the body. Investigating officers shall coordinate with Assam police. Assam police are requested to kindly assist. It is expected photographs so-and-so be made. Well, this is complete takeover.
No. Up to the stage of second postmortem,
Well, that's
let it happen. And Dr. Gupta, in the presence of the postmortem doctors and a representative of the state and a representative of the family. And where is Mr. Sandeep Kumar Bhattacharya? Where is he, sir?
I'm not sure if he has been given notice for that. He was the.
No. He is an amigo. He is an expert, is it?
He's I'm told, I didn't know that. He's a reputed criminal lawyer, my lord, practicing in Bangshal Court.
Bangshal.
Yes,
But then there should be some member of the family. If the member of the family says, I don't want to be, let Mr. Sandeep Kumar Bhattacharya.
as their representative.
That's
Obviously, I don't think the mother would be willing to be present, my lord. It's more of a-
So what can be done is let the second postmortem be conducted by Mr. Gupta, let him be paid the remuneration, whatever direction. But the Mr. Gupta will do nothing with regard to the investigation.
Naturally.
He will not. He is a retired forensic expert. Let him confine himself to his expertise.
Even the postmortem doctors, my lord, were his students.
So therefore, it's well and good that professor is doing the postmortem. They'll be too happy to witness it. They'll be very happy to see his findings. But indirectly, you can't take over the investigation.
No, that was not the intention of the honorable judge.
Makes that clear, my lord.
That we will make it clear.
I wish to place, my lord, if my lords permit, my lord, to place, my lord, two facts of the last report of the police, which were not handed over to us because of resistance from the IIT. My lord, kindly turns to page 237, if my lords feel it necessary.
Definitely.
Of this appeal, my lord. This is an extract of the last police report, page 237. The report starts at page 230.
Yes, yes.
My lord, I'm referring to the last paragraph at the bottom of the page.
After that.
Yes, the paragraph starts with that. I'm not placing even the whole of that, my lord. Fourth line onwards, considering all the documents noted above and also considering, sir, page 237, the state of decomposition along with only injuries available being multiple incised injury over the anterior aspect of the left forearm, as noted in the postmortem report by autopsy alone, no definite opinion can be formed regarding the cause of death of the deceased. And my lord, there was then the story of first it was a blade wound on the left forearm, which the postmortem report says was not sufficient to cause death. This was the first report. 3 reports were filed. Second report, my lord, the focus shifted to medicines being consumed. Now, my lord, the police, my lord, very fairly deals with that, my lord. Page 238. Next page, my lord. Next page.
Yes.
My lord, the last paragraph of the page. But he is said to have consumed, my lord, 4 numbers of beta cap 20 tablets. About 6 lines from the bottom of the page. I just, my lord, to cut short, my lord, not to take so much time. The line sentence starts with, during investigation, some medicines, including some antidepressant drugs, were seized from the room. 1 medicine strip containing 6 number of beta cap 20 mg tablets. But we have collected the purchase voucher showing that he purchased 10 such tablets. So the inference he had 4. And my lord, at the middle of the page, my lord, the police record that the fatal dose for that particular drug, my lord, the drug is actually the second of the 3 drugs listed in the second paragraph. It is called propranolol. And the fatal dose is said to be 1 gram per day, which is 1000 milligrams. And he has consumed 80 milligrams. So neither the blade wound, the blade was found on the ground, not in the room. The blade didn't have, my lord, blood on it. That's the FSL report. And now, my lord, the police themselves say this medicine was not enough to kill him. And the surprising thing, my lord, will find from page 139 of my lord's brief, that there was a second blood group found in the room. His blood group, my lord, as per IIT records, is O+. And page 139, my lords will find this, my lord, of course, my lord, with the assistance of my learned junior, I've arrived at this. Page 139, there's a AB group blood found in the room. This AB group sample was collected from near the door.
So there was somebody else present.
Somebody else present, and in the scuffle, maybe he was also injured. And my lord, that sample was collected. My lord will find that from the preceding page, 138. This is sample C and E. My lord, C and E, exhibit mark C contained 1 paper packet containing a gauge piece bearing some dark brownish stains. That is C, and E is the exhibit marked E containing some blood. But this is what was tested. The report is on the next page, and that is AB, which doesn't match with the blood group of the
deceased
writ petitioner, their son. But this is what the body looked like. The only photograph we could collect from the reporters present there. This could not have been from a blade wound, which the postmortem report says and this is Dr. Gupta's report, which is not annexed.
No.
But that is sufficiently summarized.
Their only apprehension is probably the state is not resisting a second postmortem. He is a doctor of, he is an expert in the field. That's also not in dispute. But their apprehension appears to be that this order leads to that, as if he has to take over the investigation.
No, not at all. My lords will allay that apprehension.
We also feel that indication because
my lords will kindly allay that fear, if there is any. But we could have appreciated, my lord, if the state had rushed to appeal once the appointment was made. They waited for the report to come. My lord, they in fact cooperated. My lord, they sent the case diary, the records, the photographs. Then they arranged for a spot visit. They arranged for the vehicle in terms of the order which. And now that the report is there, we certainly Dr. Gupta cannot be part of the investigation, but his presence at least during the postmortem.
These intra-court appeals have been filed by the state, challenging 3 different orders passed in WPA 23497 of 2022. All the orders concern the circumstances under which the son of the writ petitioner died, who was a student of IIT Kharagpur. The apprehension of the state is that pursuant to the orders passed by the learned writ court dated 25/4/2023, it appears that the entire investigation itself is to be done by Dr. Gupta, Dr. Ajay Kumar Gupta, a forensic expert who had retired from the services of the state of West Bengal.
He was also a professor of medical college for many, many years.
From the arguments, from the submissions made by the learned Advocate General, as well as the various grounds raised in the appeal, we find that the state has not resisted the direction issued by the learned writ court for conducting a second postmortem by Dr. Ajay Kumar Gupta. But the only apprehension of the state appears to be that in that process, the investigation should not be taken over by the said forensic expert or by any other third party. In our view, the stage is yet to come for any investigating agency to take forward the investigation, and it can happen only after Dr. Ajay Kumar Gupta conducts the second postmortem in terms of the directions issued by the learned writ court in its order dated 25/4/2023. However, we are of the clear view that the orders passed by the learned writ court should not be and shall not be construed construed to mean that the investigation will be done by Dr. Ajay Kumar Gupta, which shall be done by the appropriate investigation agency alone. With this clarification, the appeal stands disposed.
One thing, my lord, our apprehension is that because of the rainfall in Assam, my lord, this cannot wait. My lord, will kindly request, my lord.
But then the problem is, can the second postmortem, can it not happen somewhere in Guwahati or somewhere?
There, my lord, what I learned from Mr.
To transport it from there, it has to be by air.
It's just a 1-hour flight, my lord.
See, I don't know whether learned counsel has had any experience of
transporting bodies.
My lord, I have done it as a lawyer for one of my colleagues' family, and I have dealt with around 15 cases sitting as a judge of the Madurai bench of the Madras High Court. It is very, very, very difficult. Very difficult. After I came to Calcutta, I had one occasion to do it through the State Legal Services Authority. But the person was declared brain dead in the Middle East. The condition was, if we are allowed to harvest the organs, the government will send a representative and the body will be brought here. So I had to request a lot of people, standing councils of the Customs Department, the police authorities. I think I spoke to AG or ground pleader. I think I spoke to Aribandre. So many people had to be involved for it to be transported, because Fridays they are closed, Saturday, Sunday they are closed. Lot of difficulty.
With the good offices of my.
No, can it not be done in Assam is what I'm asking.
If that could have been clarified by Mr. Bhattacharya, what I learned, my lord, is that Dr. Gupta, my lord, insisted that because of the better infrastructure, he possibly has taken many classes and done similar things over there in Guwahati Medical.
Then we will not.
But my lord, because of the monsoon,
My lord, I appreciate this statement. My lord, kindly note, my lord, it's at Calcutta Medical College, my lord, where the postmortem Dr. Gupta say has better infrastructure.
That will be used at that.
No, it's very important, my lord, because my lord, there are, your lordships will find during the course of my lord PIS, it should go to Command Hospital. And I must tell your lordship, Command Hospital also sends it to PG and Calcutta Medical College.
No, the choice was of the honorable judge, the venue, my lord, which hospital he insisted.
No, suppose Dr. Gupta is of the opinion that he can fly down to Guwahati and it can be done in Guwahati, it's up to him to take a call. He can take.
My lords will make that clear, because
my lord, I'll tell you, lordships, my lord, there's no doubt, my lord, what Dr. Gupta is saying, my lord, about my lord, that hospital. My lord, clearly. Guwahati,
we leave it at that.
My lord, one thing, my lord, let it not wait further, my lord. 25th April.
Considering the sensitivity of the issue, the order and direction issued by the learned single bench with regard to the second postmortem shall be implemented as expeditiously as possible without unnecessary loss of time.
In a week, already 30 days.
Preferably within 10 days from date.
Honorable learned advocates are asking for a week's time. That may be
10 days. What is it? Server copy of this order be.
Yeah.
3 appeals common order, 9, 10, 11.
Plain copy, my lord.
Pardon?
Plain copy.
Yes.
Signed.
So what we'll do is,
I've heard that.
And you can go ask your junior colleague to go to Registrar IT. He will pull out a copy and give it.
I'm grateful.
Question of maintenance or expedition. That is recorded in order.
In this,
yes, the order is recorded in order. The order
that is your submission is on behalf of IIT, correct?
IIT Kharagpur. Not this. IIT Kharagpur is being maligned. It's being receiving a lot of press publicity. IIT Kharagpur,
AG, sir, one line you add. Mr. Mitro, learned senior advocate appearing for IIT Kharagpur, submitted that the institution has raised the question of maintainability of the writ petition by filing an affidavit in opposition. Full stop. Since the scope of this appeal is only limited to the second postmortem directed to be conducted by the learned single bench, it will be well open to IIT Kharagpur, the management of IIT Kharagpur, to canvass all issues in the writ petition.
The learned judge may be requested to decide the question of maintainability.
He will do it.
No problem.
Can we make it?
Next.
Kindly, my lord, as that the Assam police will cooperate, my lord.
That is all there. No, we have not touched that order.
Obliged, my lord.
Serial number 12.
Yes.
My lord, I appear for the appellate. This matter, my lord, the email service was made at 8 p.m. How this matter was listed also
My lord, no hard copy has been given to us in spite of repeated requests. My lord, I do not know it was, we got an email.
No, Mr. Dattu made a mention. He gave a slip saying that because of the dismissal of the writ petition, there is some consequences,
My
etc.
lord, dismissal of writ petition 1st May. There is a tender issued
Yes.
for his work, which he did not do
At my risk and cost.
on 6th May, and last day of the vacation, he comes, my lord, and shows urgency and does not serve a copy of the writ petition and serves, my lord, by email at 8 p.m. My lord, at 8 p.m. he gets I do not have any brief. I know facts.
No, we thought the order was passed day before yesterday or something. No,
No.
it was passed on first.
Yes.
Then you please serve.
My lord, your lordship may kindly take it up, my lord, today sometimes.
Yes. The learned advocate appearing for the appellant shall serve papers on the learned advocate appearing for the respondent. Let the matter be listed in the first vacation court.
My lord, there's some urgency, my lord.
No, sorry, sir. Next.
Serial
number 13.
My lord, I am for the petitioner, my lord. Last occasion.
Yes.
Lordship, I am for the contempt, Lordship.
You made some submission that it is not your intention. That is one portion of the order has been complied.
Yes, my lord.
No, Lordship, that full order has been complied. Lordship, we have filed the compliance report on the last. That is already filed, Lordship.
Last occasion, my lord granted liberty to file exception. It is ready, my lord, but it could not be affirmed because the petitioner is on duty, my lord, and he has not been granted.
Maybe you will keep it after vacation. But you serve a copy today.
Lordship, may kindly.
The learned advocate.
Only one thing, my lord, 2 points are there, my lord. Service has been regularized. Kindly come to the compliance, my lord.
No, that we'll hear after he gets instruction. You bring it on record. The learned advocate for the applicant submits that exception to the compliance report has been made ready, but could not be affirmed since the applicant is on duty elsewhere. The time for filing exception is extended by 3 weeks from date. Let an advance copy be served on the learned advocate for the
Kindly grant me time for 4 weeks, my lord.
4 weeks. List the matter after that. You give a date.
30 June. June 30.
June 30.
Yes.
13 at 30. 13.
As you.
Grateful, Lordship.
Thank you.
Well, I have mentioned this for small correction, my lord. Yeah. Page 2, my lord, will find 4th line, my lord. The date will be 2014, my lord.
Sir, please take down. This matter has been listed under the caption to be mentioned. It is pointed out by the learned advocate appearing for the appellant that there are certain corrections in the order and the following corrections be carried out. In page 2, the date shall be mentioned as 17th February 2014 instead of 17th July 2024. In the second paragraph, in the second paragraph in page 2, instead of the word containers, it shall be mentioned as consignment.
My lord.
In page 3, in the last paragraph, instead of 2011-13, it shall be mentioned as 2012-13. And in page 4, in the second paragraph, instead of the word 6, it shall be mentioned as 60 days.
Very grateful, my lord.
The necessary correction be effected in the order dated 8/5/2023, and this order shall form part of the order dated 8/5/2023.
May I take a server copy from the registrar, my lord?
Yes.
I'm very grateful, my lord.
Grateful.
Next.
My lord, I believe the matter was mentioned, my lord, before your lordships, my lord, only for one reason. My lord, the appeal, my lord, I had concluded my submissions. Then, my lord, that was before, my lord, the then Chief Justice, the bench presided over.
Yes. Somebody mentioned this.
Yes, my lord, Mr. Siddiqui mentioned, my lord, matter. And my lord, there was a contempt petition filed, and my lord, a statement was made that my lord, the contempt would not be proceeded with while my lord, the appeal was
Yes,
being
we saw the order.
Yes, now, my lord, what has happened, my lord, one day, my lord, we were not present when the contempt was called on. Submission was made that we are, my lord, taking time, my lord, in appeal. The order showed they have taken time, my lord, after I've concluded my submissions. All the orders, my lord, your lordship, my lord, 25th April 2023 is, my lord, the contempt application.
What happened on 15th May?
You said that the matter is running in the list.
My lord, it was brought to my lord, but my lord,
As item number 1.
it was,
No, no. On what date that interim order was granted? By
my
the-
lord, your lordships will, my lord, find, my lord, of my lord, the division bench, my lord, your lordships, my lord, take the order. My lord, no, my lord, this was an assurance. My lord, there was no, my lord, order as such. But 3rd February, my lord, is when I, my lord, finished.
All right. We have heard the learned Advocate General appearing for the appellant, assisted by Mr. T.M. Siddiqui, learned Government Counsel. It appears that during the pendency of this appeal, there was an understanding that the contempt proceedings which was filed before the learned single bench in CC number 57 of 2022 will not be pressed by the respondent writ petitioner. The learned Advocate General submitted that an opinion has, that it has been represented as if the appellant state has been seeking for adjournment. On the contrary, the appellant state had concluded its submissions
On 3rd February.
3rd February 2023, and at the request of the learned advocate for the respondent, the matter stood adjourned to 17th February 2023.
On 17th also they took time.
On 17th February 2023, we find that the learned counsel appearing for the respondent sought for time to place certain records, certain documents on record. And the matter was adjourned to 10th March 2023. And on the said day,
on 17th March.
10th March 2020. Subsequently, the matter was listed on 17th March 2023. And once again, at the request of the learned counsel for the respondent, the appeal was adjourned. Considering these facts, we are of the view that the contempt proceedings shall remain stayed till the appeal is heard, as the division bench Sir, actually, you have concluded your submission.
Yes, I have to start again, my lord. That's the thing.
No, one of the judges available.
Yes, it can be there.
Since substantial submissions have already been made in the matter, and one of the honorable judges forming part of the division bench is
kindly do it here, because I'll have to argue again, my lord.
Then
I'll do it here.
let the appeal be listed for directions. Sometime you give a date, 3rd week, 4th week.
4th week.
What is the issue involved?
My lord, it's under the incentive scheme. My lord, here, my lord, the only point, my lord, which the state has is, my lord, which I feel I should argue, not the other points, lots of other points were taken. My lord, is, my lord, there was, my lord, for recovery of the incentive, my lord, proceeding under the Insolvency Act was filed. My lord, not really recovery, claiming that as a debt due and therefore to go on to resolution plan, etc. Praying, my lord, that default, showing default to have occurred. That proceeding got dismissed on the ground, my lord, that claim was barred by limitation. So, my lord, thereafter, my lord, to have a writ. Writ was filed, my lord. Thereafter, my lord.
But the writ court says that proceeding under NCLT will not be a bar.
No, the proceeding is not a bar, but the finding of limitation, my lord, would, my lord, your lordship, the discretion is there. I'm not saying, my lord, writ jurisdiction is bound by Limitation Act, but generally, my lord, the writ court accepts, so it's a very short point, which is why I finished, my lord, in, my lord, 5 minutes, my lord, before the.
This is 3 to 9. Huh?
No, just
item 2.
Public interest litigation after item number 3 to 9.
My lord, in this matter, my lord, we are in the, my lord, in the item number 9, your lordship passed on order on 1st May, my lord. 3 to 9, my lord, but the item number 9 is, my lord, your lordship's order directing the state government to look into the matter regarding the payment and finance part, my lord. I'm appearing for the land special officer, my lord. And your lordships also desire on the last occasion that somebody put a question, what is the amount lying in the hands of the special officer as on that day? I have got a chart, my lord. And today, my lord, there are certain orders passed from this court. The one property of the Assam court was sold, my lord. But
then you file a short report.
No, my lord. And I have already made a statement, exact amount. I can give a copy to the other side.
We have already sent the amount, my lord. It will be in their account within a day or two. It has been, your lordship kindly sees, one is of around 28 lakhs, other is of around 5 lakhs.
And
5 lakhs.
No, but I have some submission to make here. Your lordships will your lordship will remember the last occasion. Your lordship's order says stamp duty, registration, and other charges. So when, my lord, we insisted, your lordship's desire was that let them pay the stamp duty and registration charges first. Then you tell what are the other charges. Because, my lord, I got a chart.
What is the amount represent this amount? You said,
your lordship,
stamp duty
one is of 5 lakhs and not 5,17,000. Lordship got that total amount, net amount.
Yes.
This includes, my lord, the stamp duty and the registration charges.
Very good.
And the next amount is with regard to the other conveyance. This is bill net amount is 28 lakhs 20,120. It also includes the stamp duty and the registration charges.
Then you can.
This will be debited in the account, my lord, within 2 or 3 working days.
I'm giving to your lordship.
Applicant, in the account of the applicant. I stand corrected.
My lord will see the item number 1 relates to the stamp duty.
That is,
my lord. I'm coming after. Yes, my lord. Item number 2 is the registration charges.
Yes, that is also refunded.
And your lordship's orders, your lordship and other charges, which I have to reimburse to the purchaser for cancellation of the sale, which is collected by the government. That is the item number 3. Areas of the panchayat tax, 72,000 rupees. Then, my lord, settlement tax, 95,000 rupees. Now, my lord, in terms of order of this court, because they paid the money, we are paying interest 6% to the purchaser because they paid this. So that is why I claimed interest, my lord.
So
the interest is from, my lord, the date of
serial number 3, 4, and 5 have to be settled.
3, 4, and 5 have been said that. I'm giving a copy to other side.
To these issues, my lord, because we have to take instructions. Your lordship may kindly recall, we were directed to refund back the registration fees and the stamp duty, which we have done within a day, 3 days, my lord. It will be there in the account of the applicant.
I appear for the successful purchase, my lord. I have received the stamp duty amount and the registration fee yesterday and today, my lord.
Very
well. My lord, if my lord kindly takes the order dated 24th of June 2022, passed by your lordships.
My lord, I have
there was an interest component.
No, with regard to arrears of panchayat tax, settlement tax, interest.
My lord, I'll tell your lordship, the money was paid by the special officer to the person.
Therefore, this is between them. Let the government pleader get instruction on that.
Yes,
and we will hear.
My lord, I have received that amount from the special officer.
Okay.
My
he has to be reimbursed.
Was the.
I mentioned the entire statement showing what is the exact
we have heard
amount.
the learned advocates for the parties as well as the learned advocate represent.
Small submission, my lord. But if my lord kindly takes the order dated 24th of June, passed by your lordship.
That's the order. 24th June. That's it.
What does that order state?
My lord, the order says that the interest component, which I was entitled to, that was decided at rupees 90 lakhs 18,818. Within that, we have already received an amount of 65 lakhs from the special officer. The other amount which was left was 25 lakhs 18,818. So now I have received the stamp duty and registration fee. If your lordships permit, then I shall adjust the remaining interest amount and pay the rest of the amount to the special officer.
No, my lord, I have some submissions here because I'll tell
No,
you, I
we
have
don't
only
do it.
3 lakhs in my hand. And my lord, the office of the special officer will close down. Let them pay these particular charges to me, my lord.
No,
Let me take
wait,
instructions,
please,
my lord.
please come, please come. We have heard the learned advocates for the parties and also the learned special officer. The statement of showing payment made to Evergreen Complex Private Limited towards stamp duty and registration charge, panchayat tax, settlement tax, settlement tax, including interest calculated at 6% per annum from the date of payment, has been submitted in the following tabulated format.
And copy also supplied to the other side, my lord.
The learned government council has produced proof to show that the payments in serial number 1 and 2 in the above tabular column has been made. And the same will be credited into the account of the special officer within 2 days.
They have received it, my lord. They are saying that yesterday only they have,
Has
not
been
the
paid.
applicant, my lord, not the
And
special
has
officer.
been paid, and the respondents have also and the parties have also accepted the payment. The special officer, learned special officer would submit that the arrears of panchayat tax, the settlement tax, and the interest calculated at 6% per annum has also to be paid to the special officer. The learned government council has been furnished with the copy of the statement, who seeks time to get instruction in the matter. Let the matter be listed on so and so date, whatever date you want.
Only one, they are in
indulgence.
excess of receipt. They are in excess of receipt, so that.
My lord, we are not in excess of receipt. My lord, I am entitled to 25 lakhs from the
First,
special
let
officer.
this come
Yes,
through,
my lord.
then we will decide.
My lord, may I make payment of the rest amount which is remaining with me?
He wants
I'm in
to
excess,
remit it
my lord,
to
I am
you.
already
No, my
carrying a
lord,
check.
and what I feel, my lord, I have to take instruction. Your lordship kindly direct within which period they will pay the balance money, and your lordship fix a date will come. I'll take
No, let him
instruction.
get if he wants to argue on saying that no interest is payable, we have to hear them.
Yes, my lord. In that case, my lord, your lordship, after they make
No, the submission of the learned advocate is he will pay the excess amount to you. Are you willing to accept?
Yes, my lord, let
Yes,
me,
my lord, I'm
without
paying it right
prejudice,
away.
will
You are
accept.
appearing for which
My lord,
response?
I am appearing for the applicant in GA 32, my lord. I am the successful purchaser.
But
He is the purchaser.
Evergreen Complex, my lord.
GA 32.
Yes, my lord.
Evergreen
What?
Complex.
Huh?
Evergreen Complex, by whom they paid the
Evergreen
money, the
Complex.
purchaser, my lord.
The applicant in GA 32 of 2020, the purchaser, seeks leave of this court to repay the excess amount,
Yes, my lord, I am carrying the check. my lord.
repay the excess amount to the special officer. Let this payment be effected to the special officer
Without prejudice to the right.
who shall accept the same without prejudice to their rights and contentions that they may
Deeply.
canvass.
Deeply.
Next, that's all.
My lord, wishes my lord to dispose of my application, my lord, nothing remains in the application. my lord.
Let it remain. Let it.
And
Your
my lord,
lordship, I
balance-
kindly mentioned, my lord, one
balance
second,
amount,
without
item,
prejudice to the rights and conditions for all the parties.
Right and contention of all the
All
parties.
the parties.
and my lord, the
My
balance
lord, not
amount
the
to be paid
successful
within
purchaser,
which
my lord.
period,
I
my
am the
lord?
aggrieved party, my lord.
Next,
The
separate,
balance amount.
For admission, item number 10.
they will get instructions. Yes, sir.
There's not enough time. Lord. May they be on the
The next day,
19th,
30th,
Lord, I'll be coming back late.
19, all right. The remaining list you give whatever convenient date you want.
And all the other matters of order.
So,
Justice, may I have your lordship's kind leave to move it urgent motion before your lordship in the vacation bench on 22nd, my lord.
no, you move the vacation court.
No, my lord, unless the leave, my lord, granted by my lord, I can, this matter would not be listed.
You go and mention. We shouldn't do that. You are seek leave from the concerned.
My lords are rising before vacations. My lord, subject to my lord's convenience. I come from outside. If date can be fixed, it can be taken up slightly higher on the board, my lord.
Which matter?
It is 16 number in the original list, my lords.
16.
If on 12th, it can be taken slightly on the higher side, my lord, subject to my lord's convenience.
Normally, if otherwise we would have reached 16.
Yes, my lord.
Whatever date is convenient, you
Yes.
please. Who appears for the respondent?
Respondent, Mr. Siddiqui, my lords, Mr. Siddiqui.
You please inform. Mr.
I'll inform, my lords. I'll definitely.
You take a convenient.
I am so grateful, my lords. My friend is there, my lords. I'll, my lords.
Yes. He wants a specific day because he is traveling. So
I'm grateful.
all right. Happy holidays.
Grateful.